Sorry about that, Your Honor. I just got off work and it really slipped my. I literally just walked in.
It's okay. I just walked in too. All right. So we are here today in what is supposed to be a restitution hearing. Ms. McGoy, I'm sure your attorney did advise you that we had some discussion earlier about this matter. And I don't know if the attorneys want to place anything on the record at this time.
I'm happy to.
Okay, go ahead.
I'm happy to, Your Honor. So just to sum everything up in terms of how we got here today, Ms. Pitts McGoy was sentenced on this case. This is an embezzlement case that was originally $1,000 to under $20,000. There was a plea taken with essentially to a lesser charge during the PCC and exam stage. And that was to the 200 to under 1,000 amount. The plea form in this case does indicate that there must be a reasonable amount of restitution repaid. At the sentencing that we had in this court, there was a lot of discussion about, I guess, in confusion, I think, to some extent, with Ms. McGoy feeling like the nature of the plea that she took, which was no contest, affected how the court would see her having a conviction in this matter and what, if any, restitution she felt like should be paid or ought to be paid or that she was required to pay. There was some discussion at that time that there were some of the things that she felt like, yes, she was involved with, but others were challenged at that time. So it wasn't set for a hearing at that point, but we, at the next review date, I indicated I would go through everything with the fine-tooth comb to see what the issues were, because we had just gotten that file from another court. So of course I wasn't super familiar with it at the time. I had since done that. And so that sentencing was held in October. The following hearing, it was on October 12th. When we came back again, that was on, let's see here, looks like December. And I said at that time, I've looked at everything. It seems pretty straightforward to me. So if there is something being contested, then I needed to basically know exactly what was being contested, what the dollar amount is, what the items are, what exactly the issue is, so that we can, look into it. The total amount of restitution request that I was familiar with was $4,598 for everything. That included a number of different items, merchandise from the store, cash from the drawer, and lottery tickets. So we adjourned at that hearing in December so that Ms. McGoy could have a full and fair opportunity to review all of the discovery in this case, which includes the police report itself, documents from the store, the Speedway store, which are their accounting of cash shortages, and stills from the surveillance video that document the various things listed in the complaint, and I think a few more forms and things like that are documents that basically account for everything that they reported. So the hearing following that was, let's see here, January 11th. And at that time, Mr. Lebo, I think, indicated that he had an opportunity to review everything with Ms. Pitts McGoy, and that there was a request to hold a hearing because she was contesting some of those things. So I needed to know, again, exactly what was being contested so I could figure out which witnesses to call, who we needed, and what those issues might be behind those different things. I needed that by the 16th. And we're not actually set up to have a hearing today because Mr. Lebo did reach out to me and state that he doesn't have any specific amounts or items. The general issue at this point, I'll let Mr. Lebo clarify that if I'm misstating, is that he would have wanted to question witnesses on whether the items were really taken by Ms. Pitts McGoy or whether they were simply misplaced or lost. And so we discussed on the record, or actually off the record a bit in the breakout room this morning, those go back to the central issues from the first sentencing, which is that's a trial, right? That is determining whether or not an offense happened and whether she's the person responsible for it. So we have reconvened now to discuss where this case is, what the dispute is, if any, what the specifics are, and what needs to happen going forward. Sorry, I was so wordy, but just a big recap of everything.
I do want to clarify a few things on that for my Your Honor.
You may.
Which I think part of the issue is that I did not have a list of the specific items that were alleged to be taken. My assumption at this moment is that they're in the Excel sheet I received, and that I have reached out to Ms. McDuffie regarding getting access to because it was locked by the 7-Eleven staff. So presuming that I'm able to open that Excel sheet, that it doesn't contain the list of the allegedly taken items, which I don't actually know to be the case at this point, then I think I may be able to have a discussion with Ms. Pitts-McGoy regarding those specific items. Ms. Pitts-McGoy did indicate to me that her position is she would like to have a hearing regarding the entirety of the restitution and have each item proven to be taken by her by the preponderance standard, subject to an evidentiary restitution hearing. I do believe that would be distinct from a trial because the rules of evidence don't apply to the same extent and the standard is different. However, the court did indicate that the court would prefer a more itemized list.
I did indicate that. And I'm also indicating for the record and for Ms. McGoy that if we have a hearing and it turns out that she is not making a very viable claim for not having taken those items, the court will certainly take that into consideration going forward. So, Ms. McGoy, if you want to have a hearing, it better be about real issues, because if it's not about real issues, I am not going to be happy. Do you understand that part, ma'am?
Me?
Yes, you. You're Miss McGoy, right?
Yes.
Yes. Do you understand that part?
What you say again?
That if you're having a hearing that's not about something that's a real issue, I will not be happy.
Yes, I do feel like it's a real issue. I do feel like it's a real issue because certain stuff that, and I then tried to disclose that with my lawyer. Like he said, I don't know if he confused because he wasn't originally on the case, the original lawyer on the case. But certain stuff that's being accused is not, it's not true. My George never been short in that job. None of that. And I want them to prove that.
You can talk through your attorney, with your attorney through all of that. And if it's not a real issue, that's going to be a problem for you. So you should have a real discussion with him. All right. So what we need to do is pick another date so that we can actually have the hearing.
Yes, Your Honor. And I just want one thing, Mr. Lebo, I don't have any direct sort of files of that nature. All of the spreadsheets that I have are the copies that are actually scanned into the file as PDFs. I don't have any references or any knowledge of an actual file that would have generated the error that you sent me. So if you can just
so you don't have the Excel spreadsheet that he's referencing?
No, and I don't even see where it was like discussed from the previous attorneys or where that kind of document would exist in the file at this point.
I do have it as in our database as something that was turned over as discovery from 7-Eleven and was uploaded in September.
Okay. So we'll follow up about that offline because like I said, I don't have anything like that.
Picking a date is going to be a challenge. Okay. So either February 13th at 4, which I'm concerned that we may not finish our other matters before then, or February 8th at 4.
It sounds like February 8th would probably be the better option, Your Honor.
Okay.
My only concern, Your Honor, is that is that the date? That would be the date of the actual hearing if held, right?
Yes, correct.
So that being exactly 2 weeks from now, that brings me back to the issue from last time, which is I guess, would it be by the 1st that I need to have all of my details?
Yeah. So maybe I got one more option for this month to keep us in the same month. How about March 29th? I think that might be a decent day.
Sorry,
February 29th. I'm sorry. I said the same month. I said a completely different.
I think that's good. I think that gives us enough time to go through absolutely everything, find out people are available and get them here if we need to, and sort through any sorts of technical document problems that there could be.
I agree. There is one issue I'd like to raise, I guess, partially to see the court's position on this, which among the discovery, there is an item of stolen merchandise that is simply labeled as general merchandise. And I would hope that I could get a more specific indication of the merchandise.
I'm sorry, what now? Rephrase that. I mean, not rephrase it, but repeat it.
So among the items listed as allegedly taken by Ms. Fitzmagoy, there's a $1,200 line item that just says general merchandise. And I would like to know if
And you want to know what that is?
Yes, Your Honor.
Okay. Thank you. I think that's a valid question.
Absolutely. I honestly believe so that refers to the footage of going through the store, basically filling bags with things. So I think that's honestly why that language was used on the what do you call it? The plea form, which was reasonable, because if that's something that's missing, obviously that would be contestable and understood. So I will find out if that gets any more specific. Yeah, I'll find out if there's any way. I'm not sure that there honestly will be, given the nature of the accusation behind that, with stuff being stuffed in bags and taken out. But to your point, that may very well be something to contest. So I'll follow up.
Thank you.
Right. Because if they can't prove the amount, I mean, how do you even know which items were taken? So I think that we need to know how they're going to be able to show that they get to that particular number. Okay. All right. February 29th, 2024. What time did you say our last thing is at?
Your Honor, did the court mean March 29th?
No, I meant February 29th.
Oh, I apologize.
All right, we'll do it at 3:30 p.m. on February 29th. Hour and a half should be enough time for the testimony, I hope. Okay.
That's Your Honor.
All right.